Hi, everyone. Welcome to our Facebook live broadcast. I'm Steve Altition, Director of Client Partnerships here at Pacific Cascade Legal. I'm here with our founding attorney, Louis Landerholm, to talk about temporary orders in a divorce, separation, custody case. So, Louis, how you doing today?
Yeah, doing great. How are you, Steve?
I'm doing well, and I'm excited about this because this is an area that I think people get confused about what's temporary, what's not. And so kind of going through what temporary orders are, I think is going to be great. So let's actually just start with the basics. What are temporary orders?
Yeah, basically, like the term says, it's during the
Well,
it's initial orders during the pendency of a case. So in Oregon, and every state does it a little bit differently, but specifically in Oregon, how we do it is once an initial divorce or custody case has been filed, either party can file to ask for a temporary parenting plan. They're also called pendente lite orders as well. So you may see both of those terms on different forms or information, on the internet or what have you. Basically, what it means is that once that case has been filed, then we can file for a hearing to set certain things in place, like temporary parenting plan, temporary custodial decisions, temporary support, both of the nature of spousal child support, or a lot of times it's just classified as family support in a temporary hearing, and also payment of like secured debts, like mortgages, car payments, that sort of thing. The other thing that can be asked for in a temporary hearing is exclusive use of the home, and as well suit money. Suit money is basically for one parent to help to contribute towards the other parent's legal fees. And so those are the main ones that we see why we would use a temporary hearing.
So these are really the types of final orders that will come out of a divorce, and having them go in before the divorce. I mean, it's really, those are the main things that at the end of the divorce are going to end up being ultimately decided anyway.
Yeah, I mean, there's a lot that obviously gets left to the end. Like, in a temporary plan, we're not dealing with asset division. We're not dealing with, personal property. Typically, we're not dealing with, agreement of the parties. We can agree about anything. But
Yeah.
what a judge will get involved with are those specific issues, because it's, parties have been, things change, obviously. One parent needs to separate or move out, or one parent wants the other person to move out, but they won't move out. And so, though that's where we use the temporary hearing to get those orders. And to be clear, you don't have to have kids for a temporary order. We can pick and choose out of the laundry list of things that are available for the court to order. And so, one of the key components at the beginning of a case when we're strategizing, with clients is, do we want to file for a temporary hearing, and what are the things that we need to ask for? What are the issues going on that we could solve during the case itself?
Yeah. So when does a temporary order go into effect? When can a party say, ask to get a temporary order? How soon? Is there a waiting period or anything like that?
I mean, there's not a set waiting period. There's a waiting period based on court docket. So generally, when we start a case, and if we know we want to file a temporary hearing, we will file that right away and serve it from the very beginning. Doesn't have to be served at the beginning. It can be served later on. But the timing component makes it, challenging, because It generally takes about 3 to 4 months to get to that temporary hearing. And so it's not a quick change that can be made. It definitely takes some time. And so generally, we can kind of tell that a temporary hearing will be necessary or would be preferable. And so we try to file that as soon as possible if it makes sense.
Got it. Does that mean it can be filed with the petition for a divorce decree?
It can be, yeah. I mean, once you have a case number by filing the petition, the temporary motion can also be filed at the same time.
Got it.
And so then they respond, then the other party responds to all of that, and then a temporary hearing date would get set.
Can you file a temporary order in a post-judgment matter, like a modification or something?
They're not available in modifications. So yeah, you have to wait for the modification hearing to occur before you can ask. So before you can make any changes to anything.
Got it. And just to be sure everyone knows, it's not just the petitioner who can file a temporary. The respondent, when they get served, they can file them as well, can't they?
Right. Yeah. Either party can file at any time. There's the timing component becomes, important, because if you wait 6 months and then file for a temporary hearing, it's not going to happen for 3 or 4 months. So we may bump right up against trial. And so it may just not make sense to file it that late in the game.
So when you file a temporary order, how soon does it go into effect?
Yeah, it won't go into effect until the hearing's been held, judge has made the ruling, and then they will set the effective date. So they will actually set when it goes into effect. Issues like support can actually relate back to when you filed it. So there is a component of, for support purposes, it can be ordered that support starts back when you filed it. Even though you're not in court for 3 to 4 months, but you have to ask for it specifically and go through that process.
Right. And I think, like you mentioned, you don't have to file temporary orders. You can agree, let's say, on temporary child support or spousal support or parenting time.
Right. Yeah, it is available to by agreement. The other thing that happens a lot of times with temporary hearings is that, it requires a hearing in front of a judge. Every time you go in front of a judge, it costs money, because that's an expensive part of the case. The other thing is that because it takes 3 or 4 months, we can jump in and negotiate a lot of these items sooner rather than later, so that we don't have to wait the 3 or 4 months. But it puts that, basically that scheduled time on the docket. So at some point, if we can't reach agreement, then there's going to be a temporary plan.
Got it. So the other question is, how long do temporary orders last? I mean, do you set them for, this is an order for 2 months or 3 months, or does it go to the end of the case, or is there a set time that temporary orders sort of stop?
Generally, they last until the case is finalized, but it doesn't have to. So the judge has the authority to basically do whatever they want. So if they wanted to have a parenting plan last for a certain amount of time, and then maybe it changes, a couple months in or a couple weeks in, they have the authority to do that. But generally, the orders that come out of a temporary hearing will be in place until final resolution.
Right. And like you said, if some change is made, someone can go in and actually ask that temporary order to be modified.
Yeah, it's rare to go through that process just from a timing standpoint. But it's possible.
If someone wants to get one, you said you go in front of a judge. Is this they're not like where you can go quickly, get an ex parte, and then someone has to come in and object? Or is this more of a nope, someone tries to get it and a hearing is set and nobody has any sort of advantage going on?
Right, it's the latter. So unlike the status quo that happens at the beginning of the case, that is a ex parte filing where you just present to the court what has been happening. The hearing itself, nothing that you file locks anything in. It's just what you're asking the judge to review and order at that temporary hearing. And so then the parties come together with their attorneys, and there's a hearing on the merits. You present evidence, and normally around financials and that sort of thing, to then have these temporary plans put in place.
And at the end of the divorce, do these orders become permanent, or do they sort of go away and then get replaced by a permanent?
Yeah, they're either, sort of ratified at the end and locked into the final order, or they can be changed. All of them are subject to change in the final trial. And normally we see changes from a temporary hearing to the final trial, but they help in a number of different ways, from either setting what's normal, so then it's easier to potentially negotiate what the final outcome is going to look like, because a judge has already weighed in and sort of given some feedback on what makes the most sense. But certain pieces of the temporary plan, are sort of typical for them to change. Like a support order, it's typically what we see is normally the support will be a little bit higher during the pendency of the case while it's going on, because this is all new and people are getting everything sort of situated, and then it potentially drops. Or if the judge orders that the other party, pay for half of the mortgage during the case, that's going to change at the end because we have to deal with the house. And so the house is either going to get sold, or there's going to be a refi, or what have you. So that will inevitably change the orders from the temporary hearing.
It seems like these can be really important, especially for people who, one of the parties who may not have as much funds, may access to as much money, and it's all going to be settled at the end. But for that potentially year or more, they could be really ruined almost just by not having some of that support. Are there certain ones that you generally look at and say, we need to get a temporary order on this because you need to have this done or be able to pay for this or something like that?
Yeah, the main ones are kid orders, parenting, to get a temporary parenting plan in place when maybe there's never been a parenting plan, or there's been a change in the parenting plan for enough time that a status quo isn't allowed, but we could get a change at a temporary. The other one is obviously support, because during the case or before the case, maybe one parent stops paying for things, and so we want to get into court to get an order that says this is the amount that each party is going to contribute towards the house, or towards whatever it may be, but specifically child support and spousal support can get turned on at that point, so that one party has the funds available to live during the case.
Right. And I think you talked about suit money.
Yeah.
And that can obviously help the person, with their divorce case.
Yeah, suit money is less common. It's not used as much, but essentially it's if one party has sort of control over all of like the liquid cash and the finances, and the other party just doesn't have access, then suit money is allowed to help that other parent be able to finance their case. And so that's one of the things that we look at. The other one that comes up not as frequently as others, but the exclusive use of the home is one where it's not a restraining order, but the judge can order that one of the parents moves out of the home. It's not always granted, depends on the facts of the case, depends on the finances of the parties. But generally, if it's a contentious situation where the parties just can't get along, and there's either abuse or threats of abuse or what have you, then the judge can order that one of the parents is going to move out within a certain amount of time.
Right, right. And it's interesting. There are other orders that we're not really going through today. We'll go through it another time probably, that also can pop up during a divorce, but aren't necessarily considered temporary. Aren't they?
Yeah, there's a lot. There's a lot of different motions that could be filed, during the, if you needed like a custody evaluation or a parenting plan evaluation that has something to do with parenting time. It can be presented at a temporary, but it doesn't have to necessarily be presented. And so there's a lot of different components during the course of the case that can definitely pop up. These are just sort of the traditional ones, the ones that we see the most often.
You talk to a lot of people who talk about the need for a premarital agreement. We need to get a prenup because we want to make sure everything is going to be done this way or whatever. Is it possible for a premarital agreement to override some of the temporary orders?
So the prenup could be used at a temporary hearing as evidence as to what the parties agreed to before, and ask a judge to potentially guide their decision in like support. Generally, support's going to be the one piece that I guess the paying for secured debts could be a piece of that too. But the temporary order is independent of anything else. And so the party who potentially wanted to say, we have this prenup, there shouldn't be temporary orders, that would be their argument at the hearing. But the judge has the authority to kind of set whatever, because a prenup by itself doesn't do anything until the judge adopts and enforces the prenup agreement.
Well, we're almost out of time, but is there any sort of, I guess, words of wisdom again, I'll use, that you can talk about, that you tell clients, especially in the first couple of meetings, about temporary orders, when to use them, when not to use them, how to prepare for them?
Yeah, I think there's a lot of discussion at the beginning of cases surrounding temporary orders because there's pros and cons. The pro obviously is that we can go and turn things on that maybe otherwise wouldn't be ordered. The cons is the amount of time that it takes to get the temporary order, and also maybe you don't want to change anything and you just want to keep everything intact. It is an added cost component. And so we're constantly thinking through with clients, does this case make sense for a temporary plan or temporary support? And, a lot of times we can get most of the issues negotiated. And so whether we actually end up in court or not, just getting the filings done forces some of that conversation.
Yep, that makes complete sense. Well, thank you, Louis, for sitting down today with us again to talk about temporary orders in a divorce, custody, separation case. Really, really great stuff to hear. Thanks so much.
Yeah, you're welcome, Steve.
And everyone, thank you for joining us today. Again, anyone with any further questions, please feel free to contact us. We'll get you connected with an attorney who can help you. And until next time, stay safe, stay happy, and be well.